Hi, I'm Chris Chimicles, president of Angeion Group, and welcome to our Leading Litigator series. Our series brings together some of the best and brightest class action practitioners from both the plaintiffs and defense bars, and most importantly, the attorneys that made case law. Enjoy our series.
Hi, I'm Steve Weisbrot. Thank you for joining us for another episode of Angeion's Leading Litigator video series. Today I'm here with Todd Jacobs, the managing partner of Shook, Hardy & Bacon Chicago office. Thank you for joining us, Todd.
Thanks for having me, Steve. It's a pleasure to be here.
Todd, you've had a long and distinguished career at a number of law firms, litigating class action cases, litigating commercial cases. You're now, very recently, the managing partner of Shook, Hardy & Bacon. Can you take us through how we've gotten to this point in your career and just give us your general background?
Right. First off, thanks for saying that, Steve. I started off at a large litigation firm here in Chicago, Sidley and Austin, and then went to Grippo and Eldon, which was a commercial litigation boutique here in Chicago. It had about 40 lawyers. We were open for 26 years. I was there 23 of those 26 years, was the managing partner the last 8 years of the Grippo and Eldon reign, and then we decided to hook up with Shook, Hardy & Bacon, who were lawyers that we've been working with for decades, and got into talks with and decided that the two firms were so complementary and could have such a great platform if put together. We were very strong in commercial litigation. We also do a lot of class action work. Shook is very good in those areas as well. They've got a preeminent practice in products liability, in pharma, in IP litigation, and we thought if we put those two models together with a national platform, we'd be able to have a better service arrangement for all of our clients. And we just opened our doors March 1 here in Chicago, and everybody is really thrilled and excited to go forward.
That's fantastic. Thanks. Todd, obviously arbitration is a particularly hot topic right now, and has been since Concepcion and Italian Colors. We've had the opportunity to discuss your views on arbitration previous, and I think you bring to the equation a particularly interesting calculus as to how arbitration fits into our general legal system, and I'd really like you to share that with our viewers.
Okay, thanks. I'd be happy to do it. We've been doing arbitration issues, and I've personally been doing arbitration issues for close to 25 years now. And a lot of people have this idea that the Concepcion case and the American Colors case kind of really changed the landscape with arbitration law and made it a uniform practice nationwide that consumer arbitration agreements would be enforced if they have a class action waiver in them. It is true that it made the law uniform nationwide, but it's a little bit of a misconception to think that that wasn't the law most places even before Concepcion and American Colors. We enforced arbitration clauses all over the country, and there were a couple of outlier jurisdictions, mainly California and mainly the Ninth Circuit, where class waivers ran into issues. And if you look at the Supreme Court precedent over the last 20 or so years, virtually every case that the Supreme Court has decided, with the exception of the Italian Colors case, which came out of the Second Circuit after Concepcion, they all came out of the California state court system or the Ninth Circuit, where those courts had been enforcing what they called substantive unconscionability to invalidate arbitration clauses. And the Supreme Court basically said, no, that's not right. The Federal Arbitration Act preempts state law. And that's what actually the rule that most circuits and most state Supreme Courts had followed, even pre-Concepcion.
Now I'm going to push you a little bit on that. The Federal Arbitration Act, as it was originally conceived, my understanding was between two commercial entities. And I think that the plaintiff's position that it now involves consumers who are bringing lawsuits against corporations changes that calculus. Do you have a view on that?
Yeah, I think historically that's not accurate. I mean, the Federal Arbitration Act goes back to 1925. There was no exception made for class actions, in large part because there was no such thing as a class action in the U.S. in 1925. It wasn't until the 1938 equity rules came into place that we even had class actions. The modern version of class action practice really started with the 1966 amendments to the federal rules, where you have B3 opt-out classes, which are the predominant form of damages now. And there was never any exception in the Federal Arbitration Act for class actions, quite the contrary. And there's not been an exception made in any federal statute that I'm aware of since 1925 that would exempt out class actions from the Federal Arbitration Act's arbitration command, and Congress could easily do so if it wanted to. It's been 90 years now. Federal Arbitration Act has not been amended. Any statute that gets passed by Congress could have that exception, but it doesn't.
So obviously another hot topic that is rearing its head all over the class action, especially the consumer class action landscape, is ascertainability. The issues that are at play are primarily a defendant's due process right, which stands in stark contrast to a potential claimant's right to bring a lawsuit for a small value item where they might not have proof of purchase. Given your unique perspective, doing so much commercial litigation and class litigation, what say you?
Okay. This one is because we do a lot of commercial litigation, which are typically, plaintiff X against defendant Y. And when I look at class action law, I look at it from the lens of why would a class action rule be different than what would happen in plaintiff X versus defendant Y? In the typical commercial case or civil case, the plaintiff is going to have to prove that it bought the defendant's product to have a claim. What the plaintiff's bar is saying in class actions with ascertainability, that they should be able to say that at the end of the case with just a declaration from a plaintiff in the claims process that I bought, say, toothpaste, with a declaration with no other proof. The problem with that is that in the civil litigation system in general, that sort of thing should be tested by the defendant, or at least there should be a right for it to be tested by cross-examination or other discovery. That's not what happens in the class action context. If you've got a class where you can't ascertain the members, and the class members are essentially allowed to just vouch for their claim without the defendant being able to test that, it violates fundamental concepts of due process. So class action shouldn't be a greater right than you would have in an individual case. And that's what the Supreme Court has said repeatedly in Comcast, in Walmart. Class actions are the exception, not the rule. They're not better than the ordinary civil case. And I think the plaintiff's bar in arguing that ascertainability isn't a real concept are ignoring these fundamental due process concerns.
Todd, we've really enjoyed having you as our guest. You bring a very unique perspective, and we appreciate your time. Thanks for coming.
Thanks very much for having me, Steve. It's really a great opportunity to be able to talk with you and your client base today.
Thanks.